a local artist and a painter for an hour, you know that something tough and difficult is coming up. You have your fun. Now you've got to do the hard work. The hard work is is about District Attorney Neil Pinkston. And this morning I said, I don't have time to reread for maybe the second time now, or maybe the third time, the important case Chattanooga versus Davis 2001. But I'm preparing for the October arrival of Airbnb and the anti-free market imposition by Mayor Andy Burke of economic development. Now, what we have an economic development office in Chattanooga, but Donna Williams will be in charge of repressing the free market. She'll be in charge of hounding the free market, of making sure that the Beijing wall of Chattanooga, a digital wall that belies the name of Gig City, does not allow entry and access into the Chattanooga market of people who are here as tourists, right? We want to block tourism in Chattanooga, and Donna Williams will be the instrumentality, the agent of cruelty, if you will, that will be enforcing the city council's unconstitutional and illegal ban of rentals of vacation spots in houses, in private houses and other houses that are available through the Airbnb and other like networks online. That's a part of the free market that only people as backward as city council would try to regulate, right? We are the Gig City, and our city council, except for Demetrius Coonrod, only Demetrius Coonrod got that one right. She was the only party who voted correctly to say no to this ordinance, which I, your host, David Tulis, on your behalf, got up before the council and took two of the 3 minutes allotted to me and said, this ordinance is simply unconstitutional. It doesn't stand muster on at least 3 grounds, violating the rights of the people in this city whom you represent. And, well, you'll find out what those arguments are if you go to Nooganomics.com. The reader at Nooganomics.com knows this problem, right? He already understands this problem and is taking measures to deal with the intelligence that I have given him about the statute and his constitutional rights. Now, the question, the reason I've been reading Chattanooga versus Davis is that it touches on one part of that claim by Mayor Burke against the free market, and the creation of a kind of Neanderthal housing market under license, right? The adults in the district, the Airbnb district, the short-term vacation rental district, they can get our permission to have a rental arrangement, private rental arrangement with other private parties. They can ask us to do that because we've made it illegal. We've made it illegal to have the Gig City in much of the town, but the part that we favor under our discriminatory policy, we can let people have Airbnb visitors through licensing and application with Donna Williams, the economic development minister, if you will. And so the question comes up about that whole ordinance and its illegality, approved by given a green light by Wade Hinton, the city attorney. The question is of the defining power of the corporation. Chattanooga is a corporation. It's under private law, as it's called. Private law is a charter that lets this creation exist as a corporation, a special kind of corporation exercising police powers for the public good, health, and safety. And there's a distinct limit to that power. But being a corporation, Chattanooga does not have criminal enforcement authority. It does not have punitive authority. Okay, it cannot punish anybody. It doesn't have that power. It does not have the authority to punish people. Now, it has the power to fine. It does have the power of ordinances, but it cannot punish people under the constitutional provision that limits municipal corporate authority to a $50 fine. And, of course, that's $50 in real money. And Wade Hinton and the city council and Andy Burke all accept the fact that we don't have real money. We have Federal Reserve notes. And so the whole meaning of $50 is really nothing. $50 in real money would be, I don't know, maybe $1,500 in paper. something like that, because even though silver is not doing well in the markets vis-a-vis the paper dollar, real money is far undervalued vis-a-vis paper. So it's a buyer. Just by the way, it's a buyer's market. If you want to buy bags of silver or silver bullion, gold bullion, those are all at discount right now due to the false hopes that keep the paper dollar very high against that other form of money, right, in the trading value. Well, I'm reading Chattanooga verse to get to the point here. There's a grievance that the High Court has seen that Neil Pinkston is accepting. There's a grievance that the court has, and it's waiting for Neil Pinkston or any other district attorney in any other county. There are 90-some counties in the state. There are 90-some district attorneys. They are representing the general, right? Herbert Slattery III, the attorney general. They're his agents in the districts, and of course, we are a district in Hamilton County. Now, this is a court case that runs about 30 pages in length, and I've read it very carefully. If you want to look at Facebook or YouTube, you can see how carefully I've marked my copy up, and I keep reading it. And this morning I said, I don't have time to. I need to really be reading some in Paul Johnson's art history book, maybe to have some better questions for artist Mickey Bonney, who's going to come, right? But rather I said I need to read this case again because of this Airbnb thing coming up, and Donna Williams is going to be fining people $50 a day. Well, that's simply not legal. The city does not have authority to do that because that's punitive, and the goal, the $50 per day fine was in the debate in city council. It was explicitly punitive, right? We were going to hurt these people so badly if they have an Airbnb house apart from our permission, or if they're doing Airbnb in the illegal zone, right? The banned zone, outside the Beijing wall of Chattanooga. We're going to punish them $50 a day. Well, it can't be done. It's simply illegal to do that because the purpose is punitive, and in effect is punitive. And this decision has a lot to say, as does an earlier City of Chattanooga versus somebody case. That's the Myers case. There is a long discussion about what a fine is and what this $50 fine rule does to limit municipal authority. Now, I've enjoyed reading my readings in municipal authority. In fact, in my one of my major stacks in my office at home, I have a whole folder of municipal authority cases, and I've had occasion to study that, looking at queer theory and the coming gay mudslide, and the city's effort to account for and to be part of that popular, very queer fad in the law, which went into effect by the High Court, and of course is going to corrupt and poison statutory law for decades to come. Even on the other end of the crisis, on the other side of the crisis, it's going to be there, making a mess of law, making a mess of people, and changing the meaning of marriage. That's what's happening in the statute. And that's because no law was changed. Just an opinion now vacates the Tennessee statute, Tennessee constitutional provisions, and all the lawyers who control things, right? Lawyers control everything. They say, well, the High Court's opinion is law. It's law. It's not law. It's just an opinion. There is no such thing as judicial supremacy. We have constitutional supremacy. And until you, my listener, and at least one other person believes that, we're going to be under the sway of these attorneys who are twisting things to suit their idol, the High Court. Their idol is the High Court. And there's no relief through the state and under the state for clear anti-Christian rules and opinions and laws. These laws are a slap in God's face. They are a slap in his face, every one of them. And the attorneys are all for it, and they are no benefit to you or to our system of government and self-government in Hamilton County. But I'm getting away from what I wanted to tell you about. Okay, so this is a ruling that talks about the limits on municipal authority, and the important point that I want to get to, that I'm trying to figure out how a cause of action can be formulated to address another problem. And the other problem is that has been brought to my attention by the erstwhile candidate for governor, Basil Marceau. Now, he has had my ear for some time in talking about this case. This case is what he keeps citing, and I've taken him seriously. I take anybody, even though he may be a gadfly candidate, even though he may have only 2 teeth. He has only 2 teeth now in his mouth, and so he sometimes mumbles, and it's hard to understand what he says. and he often does not frame his sentences very well. And so he's hard to understand, he's hard to follow, but I've given him a lot of time, and I've been reading this case more than once about police authority. And that's the question I want to get to now. We mentioned a moment ago the ethics rules for police. They are required, every officer is required to uphold the Constitution and defend the constitutional rights of the citizenry and their property rights, defend the innocent, defend the harmless, and not abuse people. They are supposed to be courteous, and they are supposed to be mindful of you, my listener. There are other questions that I'm not going to mention now on that point, but if the Constitution is to be honored and the high court is to be respected, what do we make of this decision, which has a 19-year-old grievance? No, wait, a 16-year-old grievance that Neil Pinkston, the county prosecutor, has not done anything with. And this case, at the end, the last section, just have you know that Davis could not make the argument for him, and the high court rejected dealing with the issues that are raised by the defendant and the petitioner, the appellant in the Davis case. He was a local man charged under, I think, driving while drunk or driving or speeding, some kind of traffic case. And the problem is that the way things are now, the court says, are under probable unconstitutionality. And but we decline to take corrective action at this time. Again, because Davis didn't have standing for the issue to be properly addressed. The only person who could do that to raise the questions about police authority and the punitive power of the city, the only person who had authority to do that is the DA. And the DA, at the time, I'm not remembering his name, Bill Cox maybe, did not make an argument after this ruling came out. And so we have an open sore, a festering wound in the law in Tennessee, and district attorneys are not demanding their rights and suing for their rights. And here's what they're supposed to be suing for, according to the high court. The high court says that the DA should demand that cities not enforce statute. That seems to be what this ruling says. Now, you're saying what? Well, that's the state of the law as things stand now. There has to be a petition by a district attorney that says this city or that city, whichever city is in view for that in that district, this city or that city is enforcing statute and is imposing punishments for things that are not ordinance violations. And that there you have the problem. How can a murder case be handled by the city police department? Murder is not part of the city ordinance. And for that to be corrected, for the state itself to be able to handle that case and not the municipal corporation and the police department, which is serving the executive branch or the mayor's branch, right? These are just processors, right? That's what Basil Marceau says. He says police departments have no authority beyond serving process and enforcing ordinance. So an ordinance would be, for example, a bordello, a liquor sale that's under the ordinance's authority, or things that offend the public health or morals, right? Those are things that are within the police authority. They're in the city charter as powers that the city has. But what about murder? What about rape? What about transportation violations? For them, when the city enforces a transportation violation, let's say speeding or DUI, can it do it if that particular violation is not replicated or repeated by the ordinance? The city is saying through the ordinance, we're going to enforce this state law under our ordinance because we've adopted that particular statutory provision into our ordinance. You see, there's a problem there, and I'm not giving specifics on which kinds of statutory offenses I'm referring to because I haven't listed them all out. But the case this ruling brings up the general question. Yes, it is complicated. It is very complicated. But the question is, what is the authority for the police department of Chattanooga? That's the question that this ruling, highly marked in my printout, is asking. And you say, well, it sounds so complicated, David. What's the point? You're just putting me to sleep with all this legal analysis, and you're all excited about it, and you think that because you're excited about it, I'm not going to fall asleep over it. Well, that may be so. But what I'm doing is I'm simply I'm simply asking, what is this authority? Is there warrant? Is there warrant for Mayor Burke to run a police department? Is there warrant? And if for there to be warrant, does the city charter have to be amended? Does a new private law have to be passed by the General Assembly to allow it? Now, I'm not answering the question because I don't know the answer, but I'm just raising the question for you, my listener. Now, here's what the court says. Just kind of bear with me, okay? It says, in many respects, this practice by the city of Chattanooga, in other words, enforcing traffic laws, perhaps represents the most disturbing aspect of this case. A letter from the district attorney general to the chief of police contained in the record summarizes the problem in clear and unequivocal terms. Okay, here's the problem, okay? Your directive has the potential for allowing state law violators to avoid appropriate punishment, removes my ability to enhance punishment for state law violators, and infringes upon my constitutional duty and responsibility to prosecute those who violate the laws of the state of Tennessee. Okay, so the DA is saying your actions as police chief are violating my prerogatives as the state's agent in this county. The judges go on to say, indeed, through this potential infringement, the city of Chattanooga has received a financial windfall, which, according to the city court judge himself, was a direct result of the city council passing ordinances that transferred state cases to city court, quote, thereby allowing the revenues to remain in Chattanooga. And the citation of the transcript of 1995 is given. Despite the probable unconstitutionality of the policies and practices of the city of Chattanooga, however, they go on to say, we decline to take corrective action at this time. Okay, so you have a problem 16 years festering now in the high court, and it's because the high court says we decline to take corrective action at this time. From our further review of the record, we must agree with the city that the appellant, Davis, lacks any legal standing to challenge the usurpation of the district attorney general's constitutional or statutory authority. So the high court is saying that the city police department effectively, and the city council that maintains that department, serving the mayor, right, Andy Burke, is a usurpation of the district attorney general's constitutional and statutory authority. To establish one stand, there's a discussion now about standing and how Davis didn't have the means of addressing this question or getting the court to address this question of a usurpation and abuse, an action that needs a correction by the DA of the city. And this is not just happening in Chattanooga. This is in every municipal corporation in the state. In every city that has a state corporation and a police department, you have this question, in this case, not addressed. The bar has not addressed it. The judges have not addressed it. And the district attorneys in every of those counties have not addressed it. Now, that's my question is, why not? What has happened? What do I not understand about the way things are? You know, I am David Tulis. I'm the slow man of Chattanooga. I am the slow man of Chattanooga. And I do not understand why this has not been addressed. And I think there is something that touches on the sociology of law, the connection of attorneys, barristers, law firms, people who have a stake in the judicial industrial complex, judges, the state itself, district attorneys, DA staffs, all those people who are employed by the state to prosecute people. You know, the state is the accuser. In every issue nowadays, the state is the accuser. So don't love the state. I want you to not be a lover of the state in general or the state in particular. The state is the accuser. The court goes on to say, because it is grounded in the organic law of this state, the authority of the district attorney general to prosecute according to the law must be vindicated in the face of all infringements, no matter their source. So the judges are saying there's an infringement on Neil Pinkston's authority by the city of Chattanooga, the mayor's office, Andy Burke, and his police department, and prosecutions that direct cases there. Police officers that direct cases to this court or that court, and it is called an infringement. Do you get that? Does that not just strike you as just remarkable? I mean, to me, that's just that this is the status quo. 16 years after this opinion was written, this is just remarkable. And I'll say I don't understand it. I don't get it. Nevertheless, because the appellant, Davis, lacks sufficient special injury or real interest in the resolution of this issue, and because he may claim some measure of benefit from the practice in Hamilton County, we must decline to grant any judicial relief at this time, as the infringement in this case is that of the constitutional and statutory authority of the DA General in Hamilton County alone. We conclude that the vindication of that authority should more properly proceed at the behest of that office. And then comes the conclusion in this case. So what happens, what the judges are saying, if Hamilton County District Attorney wants to have the proper authority and not have any governmental entity that's a corporate entity, a creaturely authority, not a creator authority, but a creaturely authority, then he's going to have to do something himself. He is going to have to raise the issue. In other words, as they say, he's going to have to vindicate that authority himself. The judges will hear Neil Pinkston's case vindicating his authority as against Chattanooga. And the question is for Neil Pinkston, how is it that you will be encouraged to do that? This, according to Basil Marceau, this argument is the end of policing in Tennessee. That's what he said. This argument by these judges is the end of police departments in Tennessee. That means the end of the police department in Chattanooga, the end of the police department in Saudi Daisy, the end of the police department in Red Bank, the end of the police department in East Ridge. And what would the question about what would happen after that is not in view here, okay? And that's because the judges wouldn't put it in view. They don't care. They just say their ruling is there has to be proper authority and there has to be made a proper appeal. This case is City of Chattanooga versus Davis 2001, and it's unfinished business. And the only person who has seen this in the whole county, probably in the whole state, is Basil Marceau, who is a candidate for governor, and he's said to be a crank candidate, but the fact that he has given me so much of his time to explain this problem makes me think that he's onto something. And so that's why this case, I suggest, is reason for police reform now. Because if we don't have police reform, we're going to have a challenge under Davis of policing per se. That's what's ahead. Policing per se is going to be challenged under Davis if there's not police reform. So there's a reason in the mayor's office to have police reform. There's a reason for David Roddy to have police reform. There are 4 legs of police reform, 4 legs. And if those legs are not pursued, and we have continuing abuse of the citizenry by policing departments in all the counties around Chattanooga, there's going to be a case that comes up based on Davis and also Chattanooga versus Myers. That's what I see is happening. And Basil Marceau, he's not a rich man; he's kind of a pauper, but he can do this too. This is something that he's thinking about. And he's got appellate court opinions suggesting that this case is still the law. And the question that I have for Neil Pinkston is, Neil, is this case binding upon you? And can you stand on this case to vindicate your authority? Vindicate your authority under the Constitution. This is David Tulis, and that's my question.
The Tennessee Valley's News, Talk,